Okay, we'll go ahead and get started. Thank you for attending, everyone, the NAICJA conference. And I was going to say good morning. It's 11 o'clock, so I guess technically it's still morning. My name is Stacy Smith. I'm the Chief Judge for the Fort Peck Tribes, and I'm the moderator for today. And I'm going to introduce Mr. Pivar to you. Stephen Pivar is a graduate of the Princeton University and the University of Virginia School of Law. From 1971 through 1974, Mr. Pivar was a legal aid attorney on the Rosebud Sioux Indian Reservation. For the past 40 years, Mr. Pivar has been on the national legal staff of the American Civil Liberties Union. Mr. Pivar has litigated some 200 federal cases involving civil rights in 8 different federal district courts, 3 U.S. Court of Appeals, and 1 case in the U.S. Supreme Court. In addition to all of the work that Mr. Pivar done, with the ACLU, he is also the author of The Rights of Indians and Tribes, and this is the book. It is available here. He does have some for sale. It is a valuable, valuable resource, and it's for $25, and he is selling them right outside by the registration desk if you're interested afterwards. Mr. Pivar also teaches American Indian law as an adjunct professor at NYU Law School, and that's where he is currently at. Okay, so I introduce to you Mr. Pivar. Okay.
Well, thank you so much. I hope the volume is good, okay? And I appreciate, I know that Judge Thorne is speaking too, so I wasn't sure if I'd have anybody here, so thank you for coming. I've been asked to talk about enforcement of the Indian Child Welfare Act. And the Indian Child Welfare Act, as probably many, if not all of you know, is the single most important law that Congress has ever passed to protect Indian children, Indian families, and Indian tribes. The law was passed in 1978, 39 years ago. And yet, today, state officials around the United States are refusing to apply the law. Some or many openly criticize the law. We have found violations of the Indian Child Welfare Act in virtually every state. And we, after speaking with tribal officials in South Dakota and doing a preliminary investigation, we found so many violations of the Indian Child Welfare Act in the Rapid City area, Pennington County, Rapid City, the second largest population in South Dakota, just under Sioux Falls, that we decided to do something about it. So what I'd like to do in discussing enforcement of the Indian Child Welfare Act, and by the way, normally I like walk around, I don't like being riveted in one place, but I've been asked because they're videotaping this to kind of stay here. So I hope you don't mind that I'm kind of fixed in this one spot. But in order to really appreciate ICWA, and in order for me to explain the subject about enforcement of ICWA, it's really important to have an understanding of why ICWA was passed. What was the purpose of ICWA? Because obviously the enforcement of this important federal law should be geared to and be responsive to the goals that Congress had in the first place. And that's how we presented this to the judge in Rapid City in our case, that here is the clear legislative history. This clearly is what Congress was hoping to achieve. And therefore, when you compare what Congress had in mind to what state officials are doing, you can see the improvements that need to be made. So let me really start off here the way we started off our case when we explained it to Judge Viken, and that is to spend at least a few minutes here anyway in discussing the purpose of the Indian Child Welfare Act. really the history of this law goes back to, the earliest days of European arrival in North America, because as everyone knows, the early Europeans sadly viewed the local peoples as savages. They were unchristian, barbaric. They didn't have the culture of Europeans, so they were viewed as less than human. And because the populations were viewed that way, obviously they could not be raising their children properly. Obviously. Otherwise, if those children were being raised properly, they wouldn't be like this. So from the earliest days in the relationship between whites and the native peoples, there was an understanding by whites that the problem with the native peoples was in their child rearing. So this became one of the dominant themes in the 1800s as whites started settling out west. They felt that either two things must happen, because the Indians were simply in the way of westward expansion. The Indians either needed to be annihilated or assimilated. And when annihilation wasn't working, and it was very costly, both in human life and in money, then the government started to try to assimilate the native population. And here again, the theme of how to assimilate any peoples into a dominant society is to try to start at the beginning with the children. So beginning in the 1800s, the federal government not only financed but also encouraged private organizations, usually they were Christian missionary groups, to come on to Indian reservations and remove, which is a kind way of saying kidnap, Indian children from their homes and take them to boarding schools. By the end of the 1800s, there were some 200 boarding schools in the United States, keeping approximately 14,000 Indian children at any one time. Over that span of years, it's estimated that more than 800,000 Indian children were removed from their families and placed into these boarding schools. And Judge Thorne, in fact, is one of the leading historians about this, and I've attended his lectures. He has these photographs that are just gut-wrenching of Indian children being removed from their homes. And that was the policy, the stated encouraged policy of the federal government during the 1800s to try to improve, quote, improve, Indian families and Indian people by re-educating the children. Well, all of that leads up to the Indian Child Welfare Act, because this theme just was prevalent. Even after they started ending the boarding school process, largely because it became publicized how horrific they were and how evil and strong-arming they were. The children were whipped or beaten if they spoke their own language. Even after the boarding schools started to close, there was still the mentality of state social service agencies that something was wrong with Indian families and that the best way to improve Indian life was to take children out of their homes and have them raised in non-Indian homes. So beginning in the 70s, early 70s, Congress started what became about 6 years' worth of hearings. And members of the subcommittee of Senate Subcommittee of Indian Affairs went around the country, held hearings, and many Indian families and both adults who had been removed as well as parents who had lost their children testified. And Congress found a number of very shocking facts that were not in dispute. One is that between a quarter and a third of all Indian children in the United States had been removed from their homes. If this had been white kids, there would have been a revolution. I mean, it's just shocking. 1/4 and 1/3 of all Indian children. Imagine if 1/4 of all white kids were removed and placed in Indian homes, or black homes, or Latina homes. The whites wouldn't have stood for it. And yet, year after year, welfare officials were forcibly removing thousands of Indian children from their homes. Congress also found, and these aren't my facts, these are set out in the reports that accompanied the bill. These are congressional findings. Congress also found that in some states, Indians were 7 to 8 times more likely to be removed from their homes and placed in foster care or adoptive homes than white children. And moreover, the vast majority, more than 90%, of these Indian children were being placed in non-Indian homes. So here again, you just see the theme of trying to take the Indian out of the child by placing these Indian kids in non-Indian homes. Congress also found that state judges were ignorant of tribal values, of tribal culture, that they were making mistakes. One example that was given in the Senate report is that some Indian children were removed because they were living with a grandparent and not with the parent. And yet, on many reservations, it's not only common but encouraged for a child to spend a certain part of their formative life living with grandparents or aunties or uncles. But this was viewed as abandonment or neglect by many white social workers. So, and this is a quote from the Indian Child Welfare Act is 25, volume 25 of the United States Code, so 25 U.S.C., section 1901 and following. So section 1901, which is cited up there, is the kind of introduction. It sets out the findings. So I am quoting here from a part of the Indian Child Welfare Act. So Congress found, and this is set out in the act, that some state officials, quote, have often failed to recognize the cultural and social standards prevailing in Indian communities and families. Lastly, Congress also found that these removals were disastrous, not only for the children and the parents who were separated, but for the tribes. I mean, some tribes were faced with extinction. So many of their kids were being taken off the reservation or taken, removed from connections with the tribe, that some tribes ultimately would simply go out of existence. So all of these then were on the minds of the legislators who passed the law. And it's very important to keep that in your mind in discussing enforcement of the Indian Child Welfare Act, because after all, what it's about is changing this. All right, so the ICWA has two overarching purposes, and it's not a very long statute, but it contains a number, maybe 25 to 30 different requirements imposed on state officials. But it has two overarching themes. One is to finally establish minimum federal standards regarding the removal of Indian children, because Congress found that from state to state, social service agencies were handling Indian cases differently. Different states had different standards, and it was very difficult to get a handle on things unless Congress set a floor. So a large part of ICWA sets out standards that every state must comply with. And the second overarching theme was to provide rights to tribes in this process. What Congress found is that in the vast majority, close to 100%, of times in which state officials were resolving the custody status of an Indian child who lived off reservation, and today slightly more than half of all Indian families live off the reservation. So this was a common occurrence, that in nearly 100% of those situations, the off-reservation custody cases, the tribe wasn't even notified. Typical to how tribes are regarded generally, state officials wouldn't even give them a seat at the table. It was as if the tribe had no connection to these children and had no interest in what happened to them. So the second overarching goal of ICWA is to impose not just federal standards, but some of those standards give tribes rights to ensure that the tribe will be notified and heard and have an opportunity to get involved in these custody proceedings. There have been two cases involving ICWA that have been decided by the U.S. Supreme Court. The first of these is the Holyfield case that maybe later I'll have an opportunity to discuss with you, but for now I borrowed a quote from the Supreme Court's decision in Holyfield just to emphasize this aspect of ICWA, that ICWA contains protections both for Indian children and Indian families and Indian tribes. And the Supreme Court said, Congress was concerned not solely about the interests of Indian children and Indian families, but also about the impact on the tribes themselves of the large numbers of Indian children adopted by non-Indians. Given the relatively short time that we have, and I want to leave time for some questions also at the end, I'm not going to be able to discuss the features of ICWA. I mentioned that there's some 20 or 25 to 30 or so commands. I'm not going to discuss them. Several of them arise in the South Dakota case that we litigated, which is the subject I'm going to turn to now. So I will be discussing some aspects of ICWA, but by no means the majority of ICWA. Not to plug my book, but my book happens to have an entire chapter Chapter 17 on the Indian Child Welfare Act. And any of you who want much more information about these 25 or so commands, I would encourage you to buy the book. But for now, let me turn to the actual case, which is one of the few cases that have been filed to enforce large chunks of ICWA. In fact, it's the first case in the United States in a federal court that has been brought by Indian tribes and Indian families as a class action, challenging the systemic practices, the general practices of state officials that violated ICWA. All right, so here's the background of our case. And our case is Oglala Sioux Tribe versus Fleming, and it was filed March of 2013. Just very quickly, our case, and I'll be going through these in more detail, our case raises 10 different federal claims. We have already won 8 of them. The other 2 are still being considered by the judge. So we actually presented them in kind of a sequence. He's already ruled in our favor on 8 and issued injunctions requiring state officials to change their practices in all 8 areas. The defendants have appealed that part of the case. So we have already filed our briefs in the Court of Appeals. South Dakota is in the 8th Circuit, which sits in St. Louis. So we have filed our appeals in the 8th Circuit, and we're waiting for the 8th Circuit to set the case for oral argument. So nothing is yet in concrete. The 8th Circuit could overturn the 8 victories that we currently have. But here's how we went about selecting the case in the first place. First of all, here's some facts about South Dakota, and I know several people here are from South Dakota, so this won't come as any surprise to you. Based on the 2010 census, the state's population then was 814,000 people. About 9%, 8.9%, are American Indian or Alaska Native. So based on that, one would think that 8% or 9% or so of the kids in foster care would also be about 9. You know, it would be comparative. Maybe at worst, you'd have twice as many. 18% of the people of the kids in foster care would be Native. 52.5% of the children in foster care in South Dakota are American Indian or Alaska Native. An Indian child is 11 times, today, this is today, 11 times more likely to be in foster care than a non-Indian. I mentioned that the findings of Congress is that in many states there were 7 to 8 times as many. 39 years later, in South Dakota, it's worse than what Congress relied upon to enact ICWA in the first place. So ICWA has not had the impact that Congress intended it to have. And that's one large reason we filed our lawsuit. Now, there's basically 4 stages to every custody case, and I'm not going to spend much time because, again, there's so much to cover. But what we did is we met with, I lived on the Rosebud Reservation in the early 70s and worked with legal aid. I'm licensed to practice in South Dakota. I have much more familiarity with what is happening in South Dakota because I lived and worked there. So there was a series of reports on NPR, National Public Radio, I don't know if any of you happen to hear it, dealing with ICWA in South Dakota. And as soon as I heard the first report, I said, you know, if not me, who? I was now working for the ACLU, and my office was in Connecticut. But this report was concerned what was happening in South Dakota. And I literally dropped everything and arranged to go out to South Dakota and meet with tribal officials to see how we might be able to help. So we met with tribal officials from both Rosebud and the Oglala Sioux tribe, Pine Ridge, and discussed the problems they were having regarding compliance with ICWA. And we realized that there's basically four stages to every custody case. One is the emergency removal, either by a welfare worker or a police officer. Then every state has an emergency hearing following the initial removal of a child. In some states it's 72 hours, some 48 hours, some at the next hearing. But South Dakota by statute requires that a hearing be held within 48 hours. So it's known as the 48-hour hearing. So our clients were saying, well, there were race discrimination, or discrimination anyway, in the first stage, which children are removed. There was also complaints about the 48-hour hearing stage, that parents were not being given an opportunity to learn the charges against them or the complaints against them, not being given an opportunity to present any evidence. So that was another area that we could focus on. The third is the trial. After you have the initial hearing and the child is removed, then there's a several-week, often several-month period involving gathering the facts and actually going to trial, and our clients talked about abuses there. And finally, placement. If at the end of trial the judge determines that the child should not go home and must be placed, other issues arose because ICWA requires that generally you look for an Indian home, and yet statistics show that 89% in South Dakota of the children in foster care were going to non-Indian homes. So that was another area. So we had to decide which of these to focus on. We couldn't, and we knew that we couldn't do all of them, and we just didn't have the time and resources to file this omnibus case. So we actually selected, I don't know if this, the 48-hour hearing process, hoping that if we won there, we'd actually nip things in the bud. If we got children returned home to their parents at the initial hearing, you'd never get to steps 3 and 4. So that's what we focused on. And in order to give you a real good idea of what was happening at these 48-hour hearings, I actually have a transcript of one of them. So first of all, this is the first page of our lawsuit. You could see that it was filed March 21, 2013, on behalf of the Oglala Sioux tribe, the Rosebud Sioux tribe, and then 3 mothers who have lost their children, all of them temporarily, fortunately. This was foster care and not adoption, so they ultimately got their kids back. But all of them went through this 48-hour hearing process that we were challenging. Attached to this complaint as Exhibit 1 is the actual transcript of Madonna Papan, one of the 3 named plaintiffs. Here is her transcript. Now again, what had happened is that they had been drinking, and they acknowledge that and are embarrassed by it. I don't know, I've been drinking to a point that that I'm sure if some welfare official wanted to remove my children, she or he could have. This worker was extremely aggressive in their case and removed the children. So here is the transcript. Their children were removed, and they then had their 48-hour hearing. Now, before I go to the actual, this is the cover page. Please make a mental note of that date there, October 20, because it's going to have some significance in just a moment. All right, so this is the cover page of the transcript. Now, again, bear in mind that their 2 children had been removed within that 48-hour period. So here are the 2 parents at the hearing, of course sober now, apologetic, without having been without their children for 48 hours, and coming to court not really knowing what to expect and hoping that at the end of the hearing they're going to get their children back. And they didn't know of any reason why they wouldn't. It's their first involvement with law enforcement, no crimes, nothing. You know, the type of situation where if it were me or most people, they would realize, well, yes, I did make a mistake. I don't think you should have taken my kids, but in any event, here I am, and there's no reason not to give me my children back. Here is the entire transcript of that hearing. 1 page, 2 page, okay? And I mean, sometimes truth is stranger than fiction. If I had put this into a book, no one would believe it, that any person wearing a black robe as a judge would remove children like this. But you could see here that the state, I hope you could read it, but that the state is introducing everyone and saying who they are. And then the prosecutor, Ms. Utter, both parents of the children are here, and in this case we're asking the court to grant custody. And it goes on yesterday, it goes on saying that yesterday they removed the 2nd child, and it just briefly talks about the fact that Dad was arrested with the daughter in the car for driving under the influence. So the court then says, turns to both parents and says, you folks wish to be heard on this matter. And the father said, what can we say? The reason why that is significant is because in South Dakota, or in Rapid City, the parents were not given a copy of the petition. They were not given a copy of the affidavit. They were basically kept in the dark. They were not given an attorney. They simply go there. The judge then starts the case. The prosecutor mentions what she did here, and then the judge turns to the parent and says, do you want to be heard? And the father says, well, what can we say? We don't even know exactly what the proceeding is all about. So what can we say? The judge then says, well, I'm sure the department will be working with you on this matter in an attempt to get the children back to you. But in the meantime, until this is sorted out, I'm going to grant the temporary custody as requested. Ms. Utter then says the next hearing would be December 12 at 1:45. The reason why I asked you to keep in mind that October date, 2 months, 60 days was going to be the next hearing. These children were removed from their homes for an additional 60 days based on this, and I can't even call it a hearing. This simply was a kangaroo court. There was nothing that those parents could have said. They were not even given an opportunity to make a fair or reasonable response to what was happening. And based on a hunch, until this is sorted out, that was the standard. Until this is sorted out. Normally, the burden of proof is on the state to prove that there's a compelling reason to remove children. And all this judge had was a few comments from the prosecutor that discussed at most what had happened 48 hours earlier. There was not a single word on why these children could not go back, why they might be at risk by going back, only that the parents had done something inappropriate 48 hours sooner. So we're not saying that the parents are without blame, that they did nothing wrong. That isn't the nature of our lawsuit. We believed, and the judge ultimately agreed, that there has to be a process, a fair and reasonable process, that a government agent, in this case a judge, and social workers must go through before they remove children. What interest does anyone have more important than their children? So we realized a couple things. One is that not only were provisions of the Indian Child Welfare Act, which I'll discuss in a moment, being violated, but basic due process of law. The 14th Amendment guarantees all of us that we will not lose life, liberty, or property without due process of law. There was no due process here. And to emphasize this or illustrate this, I want to show you another oh, how did I do that? Okay. Hopefully I could. Oh, no. All right, I'm going to have to just. See, this is what happens when they give this clicker to somebody who's, challenged. Okay, all right. So after this hearing, the judge then signs an order. This is the order he signed. And I want to point out a couple of shocking things. Once again, this fellow should be ashamed of himself. Here's the order that he signed. And it's the temporary custody order removing these children for those 60 days. You won't be able to read this. I have a slide that expands this. Up here, he makes 3 findings, okay? Now, you have read the entire transcript. Here are the findings that he made as a matter of law following that hearing. He finds, as a matter of law, that active efforts have been made to provide remedial services and rehabilitative programs to that family. Unbelievable. There wasn't a single word on that subject, that they are removing these children because they've tried to provide remedial help to the family and it's done no good. In fact, the social services had never even had contact with this family. The judge made this as a matter of this finding. The next finding, that continued custody of the children by the parents is likely to result in serious emotional or physical damage. How did the judge reach that decision? Not one word was mentioned, even by the social worker, that if you return these children to these parents, the next thing that is likely going to happen is that they will be injured, seriously injured. And the third box that was checked, that the Department of Social Services has provided reasonable efforts to prevent the removal of the children from the home. It's just infuriating that they would do something like this. And they did this time and time again. Again, in an effort to expedite things, and I am going to try to finish in about 15, 20 minutes with this and open it up to questions. All right, so we gathered other cases showing the exact same thing. The same order that this judge used here with the check boxes was used in every case. No thought was given as to whether there was evidence to support these findings. Time after time after time, this is what was happening. So we then filed suit, challenging these these general practices of denying parents a copy of the petition, denying them an opportunity to present evidence, denying them an opportunity to cross-examine or confront the social workers who had filed these secret affidavits with the judge, denial of counsel. A lot happened during about 16 to 18 months, but to get to the end of it, given time constraints, we obtained copies of around 140 additional hearings. At first, the state balked at producing these hearings, but Judge Viken ruled in our favor that given that this was a class action and that we will simply be, the only way that we could obtain evidence about practices was to force the state to provide copies of other custody hearings. So he ordered that they do that. And what we did is we started with January 1, 2010, and we asked for every third hearing. So we got a random sample. We got 1/3 of all the hearings. There were close to 400. We got about 1/3 on every couple days we would get the transcript. All right, so here are, and then we spent literally days collating the information from these fairly voluminous custody files. Here's what the Judge Viken, he's the chief United States District Judge in South Dakota. He happens to sit in Rapid City, and that's where we filed this lawsuit. Here is what the judge found as a result of the hundreds of pages of documents we then were able to submit to the court. First, that approximately 100 48-hour hearings involving Indian children are held each year in Rapid City. We were actually surprised by that number. We didn't know that there were that many. But based on getting them, every third one, we saw that there were approximately 100 each year involving Indian families. The state won 100% of the time. Who wins 100% of the time? Who? The state won 100% of the time. Of course they did. How could a parent win? I mean, their hands were tied behind their backs. Again, they didn't have even the petition. They weren't allowed to present evidence. They couldn't say anything. They couldn't present documents. They couldn't have their friends or family members testify. They couldn't confront their accusers. So we got all these files, and the state won every single time. The judge also found, based on what we presented, that between 2010 and 2013, 823 children had been removed. 800. 123 Native children in Pennington County, South Dakota, had been taken during that roughly 4-year period. We also found that, or the judge found, that these hearings at most lasted 5 minutes and some less than 60 seconds. We began calling this the gone in 60-second case. And hardly that was a movie current at the time. And we wanted to dramatize that parents were losing their children in 60 seconds. That transcript that we went over, if you read that slowly to yourself, it won't take you 60 seconds to read it. That's how fast those parents lost their kids. The judge also found that in 77 of 78 transcripts, some of these didn't have a transcript because the tribal court transferred the case immediately, as ICWA does allow. There were 78 of these that actually went to a hearing, like the one I just did. In 77 of the 78, there was not even a reference to ICWA. It didn't matter whether it was even an Indian child. ICWA might as well have never been passed. It wasn't even mentioned in these hearings. The court also found that Judge Davis, who was the judge most of these times, never advised parents that they could challenge it, could present witnesses, confront or cross-examine, that they had a right to testify. Also that Judge Davis never required the state to put on any evidence. Hard to believe. You don't have to say anything. All I need to know is that it's an Indian kid with an allegation that one or both parents did something wrong, and I am simply going to remove that child. I mean, this is back in the Columbus days or the boarding school days. Indian children need to be removed from their families. That's the prevailing attitude. And lastly, the court, Judge Viken, found that Judge Davis always used that form checklist order. To close this out, I mentioned that we had already won 8 significant rulings. What I'm going to do now is quickly review some of the rulings in the case. I'd be happy to go into these in more detail, but we just don't have the time for them. There have been 6 important decisions from Judge Viken over this period of time. Often we would present one issue and one motion for a ruling and 2 other issues later and so forth. So in order for anybody to get the full flavor of the case, they would have to review several court decisions. What I've done is accumulated them, and here are 8 precedent-setting rulings from this case, but these aren't all of them. One, and this is immensely significant, is that Judge Viken ruled that Indian tribes have standing, they have the right to file their own lawsuit against state officials alleging systemic violations of tribal rights. We were surprised that this was the first case in federal court seeking a remedy by an Indian tribe concerning systemic violations of tribal rights. I don't know why there haven't been more cases like this. I certainly hope that there are now, will be many, but this became an exceedingly important issue because the state argued right off the bat that the case should be dismissed because Indian tribes don't have enough of an interest in the outcome of these cases to have standing to bring this case. And the court simply found that Indian tribes do have standing to mount this kind of challenge. And I would be happy to, and will, leave this PowerPoint. Perhaps they could print it out for anyone, because we just won't have the time to go through and read all these quotes. But all of the quotes are from the court decisions. The next is that the three parents have standing to file a class action. Once again, we were surprised to find that in the 38 years, or then it was 35 years, of ICWA's existence, no one had filed a class action yet on behalf of parents, showing that state officials were doing this to everybody. So it became an important ruling in our case that, yes, families have standing under ICWA to challenge general practices applying to themselves and other Native families. And that's a quote from the court decision saying that families do have a right to do that. Third, this is one of the more important issues in the case, but it's one of the more technical. In the interest of time, let me just explain it this way. All 50 states have a best interest of the child standard in determining whether to remove a child. They look at best interests of the child. That's a horrible standard to use for Indian children, because when white judges and white social workers consider the best interests of an Indian child, we know from 500 years of history that what they're going to say is the best interest of an Indian child is to get that Indian child out of the home. So Congress created a different standard for Indian custody cases, a much higher standard. And that standard, and there's a couple standards being used at different periods in the process, but at the 48-hour hearing, the standard is you have to return the child at the 48-hour hearing unless returning that child to the home, and I want to quote it, will place that child in immediate risk of imminent physical damage or harm. So it's not best interest of the child. It's imminent physical damage or harm. So you don't say, well, you know, would Johnny be better off with this wealthy white family on the other side of town? That's a best interest of the child standard, which is the standard that South Dakota officials were using. It's, if we return Johnny to his home, will it likely result in imminent physical damage or harm? That is a much different standard than best interest of the child. And the federal court agreed that at these emergency hearings, that's the standard that must be used. Fourth, a basic due process principle, that parents had a right to a copy of the petition and the affidavit that was being filed in secret by state officials and given to the judge, so that the parents never had a chance to see it. So one of the rulings, the court found that our clients were being denied due process of law because they were not being given this notice. Next, dealt with a right to contest the charges. A core due process principle is that whether you're being threatened with losing your driver's license or, you know, your household furniture or welfare benefits or food stamps, and certainly your children, the due process clause requires that you be given not just notice, but an opportunity to do something about it. to contest the charges against you. And we showed that Indian parents were not being given that basic due process right. So the court held that they were being denied that right. Confront and cross-examine. And again, I need to go through this quickly. I showed you that parents were never given an opportunity to confront and cross-examine their accusers, and Judge Viken found that that also violated the due process clause. Another very important issue in our case was right to counsel. No court had yet ruled that parents have a right to counsel at these initial hearings. Judge Davis in the state court said, well, they have a right to counsel, but not at this hearing, at all subsequent hearings. As Judge Viken pointed out, it's too late then. They have a right to counsel at these hearings so that they could try to get their child back before the damage occurs. And one of the important rulings from this case is that parents at these hearings do have a right to the assistance of counsel at that hearing. And lastly, as I showed you, the typical practice of the state court was to have this checklist. It didn't matter whether the evidence had been submitted or not. They just made up findings. The last is that whatever findings happen at the conclusion of these hearings has to be based on the evidence presented at the hearing. I mean, duh. It is amazing that the state is appealing every single one of these rulings. It was amazing that this was happening in the 21st century anyway, but what they're saying is that they have the right to do these things. That what was happening was totally fine. They're asking the Eighth Circuit to reverse every decision that Judge Viken made. So I'm going to have to just quickly go through the remaining slides. This is a wonderful quote from Judge Viken, and I hope that they'll make this available to you. Or anyone who wants this, I'll be happy to email it to them. I'll be selling the books at the table there. You just come over, give me your email address, and I will send you this slide, this PowerPoint. So you'll have all the quotations, because we're not going to have time to go through it. So Judge Viken just, I mean, you want to hug the guy. We were so lucky to find a federal judge with this sensitivity. I mean, I would like to think that any and every federal judge would have done this. It just seems so clear to us, but probably not everyone. He's just been phenomenal. And he has ruled in our favor on every substantive issue. There's been a couple little skirmishes we've lost along the way, and I'm kind of glad, because it really does show that this wasn't a knee-jerk reaction on his part. The guy has just been amazing. I hope that when the case is over, I'll have a chance to thank him personally. All right, so lastly, I wanted to mention, all right, so once the court found these violations, it then had to come up with a remedy to cure all of them. And the judge asked both sides to submit a proposed remedial plan. We submitted a lengthy remedial plan. The defendant submitted nothing. At the remedy hearing, the judge turned to the lawyers for the other side, and each of the defendants, I mean, there was a bank of lawyers on the other side, and the judge said, do you need more time? Why aren't you even, contributing to this. I'm not going to interpret this as an admission that you're doing something wrong. I'm preserving your right to appeal. But unless you contribute, I'm going to have to come up with remedies that might be broader than necessary. You know better how the system operates. Contribute something here. And they still said, Judge, we're not going to do it. I mean, they just have been resistant from day one to this case. And it's really unfortunate because everyone is suffering as a result. In any event, we had a hearing. I pointed out that, and I'll go to, before I get to that, I pointed out that the defendants had not changed any of the things yet other than they were now giving parents a copy of the petition. There was still no right to present evidence, still no counsel. They were not doing anything. The judge might have as well have ruled in their favor, and he was furious. As much as this judge would show that, I mean, he was sitting there, you could just tell how disappointed and angry he was that he had found all these violations of federal law and the defendants were simply ignoring them. So he entered a comprehensive order on December 15, and that's the one that's on appeal. Very quickly, lastly, in the 39 years that ICWA has been around, another sad thing is that the Department of Justice has not once or had not once filed a friend of the court brief in any ICWA case. I don't know why they didn't do it, because the result is that it has definitely inhibited or slowed down the enforcement of ICWA. Finally, the Department of Justice did file an amicus brief in our case, saying that the plaintiff's rights under ICWA were being violated and encouraged the judge to rule exactly as the judge did rule. So while on the one hand I do want to compliment DOJ for doing this, I also have to say, in all honesty, it's late, but much appreciated. All right, so remedies I mentioned. The remaining two claims deal with failure to supervise and train by the Department of Social Services. And those are the ones that are still in court. So really our case deals with two halves. One concerns what happens at the hearing. And the next, what happens after the hearing. 100% of the time, the kids go off to social services. We then focused our attention to what was social services doing with those kids and how quickly were they returning them. And in two sentences, I'll simply say that, two sentences that summarize a year of litigation. We found, after taking depositions, that they were not using the correct standard, that they were viewing things through a white lens instead of the ICWA lens, and we have now filed motions for summary judgment. Motions for summary judgment, just like we did on the first 8 claims. Okay, I think that's it. Yeah, good. All right. In the remaining 10 minutes or so, I'd be happy to answer or try to answer any questions that you have about ICWA or enforcement of ICWA or about this case. Please. How long am I here for? I'm on another panel tomorrow morning, so I'll be here the rest of the day and then through tomorrow morning, and I'll leave here around 11 or 12 or so. Okay, please. And I've been asked to repeat questions for the, yes?
So in the right to confront and cross-examine, was that purely a due process argument, or did it actually find
It was purely a due process argument. Good. The question was our claim regarding cross-examination, what were we relying on, and the due process clause. There have been a host of cases, a long line of cases, saying that whether you're being subjected to a loss of food stamps or welfare benefits or an automobile or whatever, you have a right to cross-examine. So we just relied on these basic cases. Please.
In the 1912 finding about, serious emotional harm, physical damage and emotional harm, there's no mention in your slides, and I'm assuming not in court, about a qualified expert witness ever testifying.
Right. And the question was, I didn't mention a standard in ICWA, and it's set out in 1912E, that requires a qualified expert witness. That standard applies to the subsequent hearing. We made a determination, and by the way, I'm glad that you asked that question for a number of reasons, one of which is because there was so little precedent, so little other cases we could rely on, this lawsuit was a group effort. Kate Fort, who spoke yesterday and who is speaking today and who is around, was a major contributor to this case, and so was Judge B.J. Jones in North Dakota, Barbara Atwood, who is a professor of law in Arizona, who has written a book about the Indian Child Welfare Act. Together, we determined that the initial hearing that Congress intended the initial hearing to be governed by a separate standard set out in Section 1922. And that standard says imminent physical danger or harm. In a subsequent hearing under 1912, the standard changes to imminent physical or emotional damage or harm. And we believed that the reason why Congress permits emotional harm to be presented by state officials in these subsequent hearings is because all of those subsequent hearings require a qualified expert witness who, as the regulations state, has to be someone familiar with the tribe or Indian culture. In other words, at the 48-hour hearing, we don't want these white, and in the vast majority, that's who they are, people saying, well, if Johnny goes back home or Linda goes back home, she's going to suffer emotionally. Who the heck can challenge that? The parents can't say, oh, no, she won't. Congress made a conscious decision to have a different standard at this emergency hearing. And they did two things that go hand in hand. One is that they removed the ability of the state to take kids away based on emotional harm. And they said that a QEW, a qualified expert witness, doesn't have to testify at that emergency hearing. In later hearings, the state can remove a child based on emotional injury, but there has to be accompanied testimony from a qualified expert witness. Okay, maybe there's time for one more question, if there is one. Yeah, thank you very much. Thank you.